Welcome to China Legal. CK Hutchison announced on March 4, 2025 that it's intended to sell two subsidiaries to a consortium led by BlackRock. This deal bundles up 43 ports across 23 countries, including 2 ports at either end of Panama Canal. CK Hutchison is under the control of Hong Kong tycoon Li Ka-shing and his family. Although only an in-principle agreement was signed, this deal has sparked a widespread discussion all over the world. In this video, I'm going to talk about the potential legal challenges this port deal may face in China. The first legal challenge is anti-monopoly review. Under China's anti-monopoly law, any transaction that may result in monopolistic practice should be put under anti-monopoly review. Monopolistic practice is also known as concentration of business undertakings in the anti-monopoly law. As clearly stated in the State Council's guideline titled "The Provisions on Thresholds for Filing of Concentration of Business Undertakings," an equity acquisition like this port deal should be recognized as a type of concentration. Also, as long as the port deal meets either of the following thresholds, anti-monopoly review will be triggered. Threshold 1. The combined global revenue of all concentration participants is more than 12 billion Chinese yuan in the past financial year, and at least 2 of them each has a China revenue of more than 800 million Chinese yuan in the past financial year. Threshold 2. The combined China revenue of all concentration participants is more than 4 billion Chinese yuan in the past financial year, and at least 2 of them each has a China revenue of more than 800 million Chinese yuan in the past financial year. When we assess whether an equity acquisition has met either of the above thresholds, we need to figure out who the concentration participants are. Well, the concentration participants in most cases include the controlling parties who will control the underlying business, and who will be controlled by the controlling parties after closing. In an equity acquisition, normally only the acquirers and the target company are recognized as concentration participants. Sometimes, if the target company's existing shareholders will join the acquirers in controlling the target company after closing, then such existing shareholders should also be counted in. Moreover, the look-through affiliates of the acquirers, the target company, and all other concentration participants should be included as well. In the port deal, at least the following 2 groups of entities should be recognized as the concentration participants. Group 1, the target companies, including Hutchison Port Holdings and Hutchison Port Group Holdings. Group 2, the acquirers, including BlackRock, Global Infrastructure Partners, and Terminal Investment Limited. Let's call them the consortium collectively. Based on our public search, it's likely that at least the target companies and BlackRock's global and China revenue in 2024 would have met the first threshold. If that is the case, the port deal will be subject to an anti-monopoly scrutiny by the State Administration for Market Regulation, or SAMA, China's anti-monopoly regulator. By the way, if the deal proceeds without clearing the anti-monopoly review process first, SAMA shall have the power to call off the deal. On March 28th, SAMA voiced out its position. The port deal should go through the anti-monopoly review process. So far as we know, no definitive agreement is signed for this deal. The second legal challenge is national security review. In practice, the most common type of national security review is for foreign investments, or FDI, in China. The FDI National Security Review Framework is comprised of comprehensive regulations and guidelines. In other words, it's quite matured. However, that framework doesn't apply to the port deal as no FDI is involved. Notwithstanding that, under Section 59 of the National Security Law and Section 12 of the Administrative Licensing Law, the State Council is empowered to subject any deal to its national security review by a provisional decree. If its decree is violated, the State Council may take necessary actions to terminate the deal according to Section 81 of the Administrative Licensing Law. The third legal challenge is data security review. The most common type of data security review in practice is for data transfers out of China. That the data review framework has also established comprehensive regulations and guidelines. However, it doesn't apply to the port deal because no cross-border data transfer is involved. On the other hand, as a matter of fact, a large number of Chinese vessels pass through the Panama ports and therefore produce massive data. Apparently, this data flow touches on China's national security. Under Section 24 of the Data Security Law, the Chinese central government is empowered to establish a data review framework to deal with national security-related matters. Coupled with Section 12 of the Administrative Licensing Law, the State Council has the power to subject any deal to its data security review by a provisional decree if there's a national security concern. Anyway, the port deal is far from over. Let's keep a check on it. I'm Jason Zhang, a Chinese lawyer and partner from a leading Chinese law firm in Beijing. If you have any legal inquiries, you may send me an email. Here's my email address. See you next time.